Good morning, everyone, and welcome to today's webinar. Today's webinar is an update on Section 125 plans and flexible spending accounts. I am Chris McCauley. I'm a benefits attorney here at ProBenefits, and I'm joined today by Jamie Rohr, a benefits consultant. Also here at ProBenefits. Today's webinar is part of ProBenefits client webinar series for 2014. Next, we have a December webinar scheduled as well. Currently, it is scheduled for December 16th, and that webinar will be a compliance checklist for 2015 and a year-end review of 2014. So you can register for that webinar on our website. The registration should be up in a couple of weeks, and you should also receive an email about a week and a half before that webinar, which will also allow you to register for the December webinar. As always, feel free to ask questions using the question box on the control panel on the right side of your screen. We will get to as many questions during the presentation as we can. Any questions that we are unable to get to during the presentation for time purposes, we will always respond to by email after the presentation. So if your question doesn't get answered, don't worry, we will eventually get you an answer. You can also ask questions by sending them directly to myself, Christopher, at ProBenefits.com. This session again is an update on Section 125 plans and flexible spending accounts. You can see just a brief outline of today's session that's going to include a refresher on Section 125 plans, talk about a few recent developments, legal developments affecting your 125 plan and FSAs, and then just have a brief discussion of a few current trends, 125 trends that we are seeing. And we will follow up the session again with your questions. So to get things started, I'm going to pass it over to you, Jamie, and you can start with a brief refresher.
Thanks so much, Chris. Thank you all for joining us this morning for the 125 webinar. Just as a quick refresher on Section 125 plans. Section 125 plans are really the only way for employees to pre-tax benefits. And you'll hear in the benefits world, Section 125 plan, cafeteria plan, flex plan, it all means the same thing. And in the world of Section 125 plans, the benefits are being pre-taxed through the Section 125 plan. Those employee contributions are exempt from all taxes, federal income, state income, FICA. Typically, that amounts to about 30% total in states that have a state income tax. The employers, on the other hand, are also exempt from the FICA match on any dollars that are being run through a Section 125 plan. The employers are exempt from that 7.65% FICA match that they have to pay on those dollars. So really and truly, a Section 125 plan, cafeteria plan, flex plan is a win-win for both employees and employers. Now, there are two basic types of Section 125 plans, flex plans. The first is, and I sometimes refer to this, no offense to Chevrolet by any means, but the first is the premium only plan. It's just a Section 125 plan that's a very basic 125 plan. It has it just allows employees to pre-tax premiums for eligible insurance plans that are included in the pre-tax 125 plan. So that's the very basic model. And now we can expand that 125 plan so we can take that Chevrolet up to a Cadillac. We can now not only have the pre-tax premium component, but we can also have flexible spending accounts. So when you're out there in the benefits world and you hear flex plan, 125 plan, cafeteria plan, it can either mean a basic pre-tax premium only plan, a POP, or it can mean a full FSA plan that includes both pre-tax premiums and FSAs. Now, when we think about what can be pre-taxed through a 125 plan, these are the items that you're typically talking about. Health insurance, so any employees that are paying premiums for health insurance, that can be paid for pre-tax out of employees' paychecks. dental insurance, vision insurance, group term life, up to $50,000 of coverage on the employee themselves. If there's any life coverage for employees over $50,000 or any life coverage for spouses or dependents, those premiums for those applicable amounts have to be paid with after-tax dollars. Accident coverage, long-term disability and short-term disability. Now, of course, we've starred those or put an asterisk beside them because if you're paying premiums for disability policies through a 125 plan with pre-tax dollars, if the employee is paying those with pre-tax dollars, then the disability benefit, should they become disabled, is then taxable. So sometimes an employer wants to leave disability out of the 125 plan, have the employees pay after tax so that the benefit, should they become disabled, is then tax-free. Flexible spending accounts. There are two flexible spending accounts. There's the Health FSA that an employee can set aside pre-tax dollars for their out-of-pocket medical, dental, vision expenses. And then there is the Dependent Care FSA that an employee can set aside pre-tax dollars for work-related child care expenses for kids ages 12 and under. So two flexible spending accounts that can be included in the 125 plan. Also, HSA contributions can be included in the 125 plan, and we'll talk a little bit more about HSAs later in this presentation. And then various supplemental products like cancer policies, critical illness, telephonic medicine, those kind of things. They can be potentially pre-taxed as well. So that's just a good general list of what can be pre-taxed and a good refresher on 125 plans. I'm going to kick back over to Chris to talk about a few regulatory updates concerning 125 plans.
Thanks, Jamie. As many of you know, there's been a flurry of regulatory activity the last few weeks, so we just wanted to touch on a couple of the new updates that directly affect your 125 plan. And the first thing I want to talk about is there is now a new FSA maximum of $2,550 per year, and that maximum is a maximum on employee contributions. The employer can always contribute more, which pushes the benefit beyond $2,550. But in terms of employee contributions to the FSA, the maximum for a plan year is now $2,550. As many of you know, healthcare reform imposed a $2,500 maximum on employee contributions for plan years beginning after December 31st of 2012. But that maximum can be indexed for cost of living adjustments, and there was no indexing for 2014. So in both 2013 and 2014, the maximum was $2,500. But the IRS has increased the maximum to $2,550 for plans beginning 1/1/15 and after. I know that this announcement came at an inconvenient time for 1/1 renewals who probably had already sent out the renewal information to employees, but we're going to do the best we can to handle it, even though the announcement was inconvenient. But in terms of ProBenefits clients, the plans that we administer, the FSA plans that we administer, are designed to automatically increase upon an indexing by the IRS. So no amendment is necessary to the SPD or the other plan documents in order to offer your employees to elect the maximum of $2,550. All you really need to do is simply inform participants about the change and let them know that on their enrollment form they can elect $2,550, and when we see the increase in the election to $2,550, we will be able to handle it. There are some plans that do not offer the maximum. So an employer can choose to cap the FSA maximum at a lower amount than the IRS allows. So for instance, we have some employers that cap the maximum at $2,000 for the FSA. Those plans are not set up to automatically change, because we assume that if a plan is already capping the FSA at a lower amount, that there's a reason they picked that amount, say $2,000, and they want it to stay there. So plans that set a max below $2,500, those plans aren't designed to automatically change with the IRS indexing, but plans that offer the full max $2,500, the SPDs are designed to allow the change. So all you really need to do is simply inform participants about the change, and we will be able to handle it on our end. Another issue it's been in the news a lot is coverage for same-sex spouses. And in order to sort of set the stage of where we are now, I wanted to look back at where we were about a year and a half ago, and that was pre-Windsor. And Windsor is the Supreme Court decision that struck down the Defense of Marriage Act's definition of marriage as between one man and one woman. So pre-Windsor, about a year and a half ago, there were really two issues. The first issue is eligibility for benefits for same-sex spouses, and second, how would those benefits be treated in terms of taxes, so the tax treatment of those benefits. And so pre-Windsor, in terms of eligibility for benefits, employers were generally free to exclude same-sex spouses from eligibility for benefits unless prohibited by their own state law. So employers could define spouse in terms of eligibility for their benefits, and were free to do so. In terms of tax treatment of benefits, so even though employers were free to exclude same-sex spouses from eligibility, they were also allowed to include them and cover them for benefits if they so chose to do so. And even if they did cover same-sex spouses, that coverage was treated differently than opposite-sex spouses in terms of the tax treatment. So pre-Windsor, a non-employee same-sex spouse was not eligible for coverage on a pre-tax basis. And basically what that meant was if the non-employee spouse was covered by a health plan, the amount of coverage needed to be included in the employee's gross income and was subject to individual state and federal income taxes and FICA taxes for both the employee and the employer. What that also meant was that the non-employee spouse also couldn't participate in the 125 plan, and their expenses were not eligible for reimbursement from the employee's FSA. So even pre-Windsor, even if a same-sex spouse was eligible for coverage under the employer's plan, they were treated differently in terms of the taxable benefits. Then, of course, last year we had Windsor. And so now we can talk about where we are now, post-Windsor, and after some agency guidance on the issue. Let's start first with the tax treatment of benefits. Now, for federal tax purposes, same-sex spouses are treated virtually identical to opposite-sex spouses. So a non-employee same-sex spouse who is eligible for coverage on a pre-tax basis as long as they were married in a state that recognizes same-sex marriage, and that's called the state of celebration rule. So if you're an employee in North Carolina, which up until a couple weeks ago did not allow for same-sex marriage, but if you were married in a state that did allow same-sex marriage, you were eligible to participate in your employer's plan if your employer provided so. And once you were eligible to participate, those benefits could receive the same tax benefits in terms of salary reduction and coverage under the FSA as an opposite-sex spouse. So just to say that in a different way, if you were eligible for benefits under your employer's plan, then your coverage could be salary reduced from your spouse's income, and also your expenses could be reimbursed from your spouse's FSA as well. So that's how the tax treatment differs post-Windsor. Now, the tougher question is the eligibility for benefits question. So Since Windsor, there has really been no federal or North Carolina state action that affirmatively requires employees to cover same-sex spouses. But employers wishing to do so really should consider the following. First, some carriers are mandating coverage for same-sex spouses, and I've seen some letters from some carriers recently that basically says that the employer needs to provide coverage for same-sex spouses and needs to communicate that to those individuals. So that's one issue to look out for. Another issue is there have been some legal challenges for that employees are challenging their failure to receive benefits on the same basis as opposite-sex spouses. I know there's at least one court case alleging sex discrimination for failure to provide equal benefits to same-sex spouses. So even though at this point there has really been no legislative or agency action which mandates the coverage of same-sex spouses, potentially there could be some litigation liability, and that's something we need to look out for. So we will keep you up to date on that as well. And finally, the third issue is there could be some communication or PR issues. I know that we have heard from employers and some advisors that there are employers that are staunchly opposed to providing benefits for same-sex spouses and don't plan to do so in the future, but I think it's just important to realize where the law is moving on this issue, and more than likely within the near future we're going to hear from federal regulators and state regulators, and at some point, I don't know whether that's next week or next year or a couple years from now, but at some point states, carriers, and employers are going to have to treat same-sex spouses the same as opposite-sex spouses. This issue has, even if it's not in stone, seems to have been settled. And again, finally, last month's Supreme Court decision not to hear appeals of the Fourth Circuit gay marriage decision in Bostick v. Schaefer, that really hasn't changed much of the analysis in terms of benefits. What it has done is it has, there are now states in the Fourth Circuit, including North Carolina, where more people are, same-sex spouses are eligible to get married, but in terms of the benefits, it really hasn't changed much of the analysis. Moving on to another topic, another change for your 125 plans. There are two new Section 125 qualifying events. Many of you know that when an employee makes an election under a Section 125 plan, let's say for group medical insurance, that election is irrevocable during the plan year unless the employee experiences a qualifying life event that permits a change. So if I elect to pay for my group medical coverage by salary reducing $400 per month, then that election cannot be changed throughout the plan year unless I experience a qualifying event. Well, we have a pretty set list of qualifying events allowed by the IRS that really don't change from year to year, but just recently in Notice 2014-55, the IRS did add two new Section 125 qualifying events. And really what this was meant to address was enrollment in the marketplace. So just as an example, enrollment in the marketplace or the federal exchanges or a state exchange was not a qualifying event prior to the notice. So if I enrolled in my group coverage for a non-calendar year plan on August 1st, then I was locked in for the full year. And if on January 1st I wanted to go to the marketplace because I found that I could get a plan for cheaper, I wasn't able to drop my group coverage because there was no qualifying event. But the IRS has changed that, and now the IRS now says that an employee can drop medical coverage mid-plan year in order to enroll in a qualified health plan through the federal marketplace during marketplace open enrollment or a marketplace special election period, and that special election period is really similar to a qualifying event. So again, this really solves the election lock problem that employees were facing, especially employees whose employers' plans were non-calendar year plans. They were stuck on their group plan and they couldn't drop their coverage mid-plan year to go get coverage on the marketplace. But the IRS has solved that problem by adding a new qualifying event. And there was a second qualifying event added, which says that an employee can drop coverage mid-plan year if the employee's hours of service drop below 30 hours per week and the employee enrolls in another medical plan, even if the drop in hours does not affect the individual's eligibility under the plan. So let's say, for instance, I was working 40 hours a week and I elected coverage under the group plan. Let's say something happens mid-year and for some reason my hours get dropped below 30 hours per week, down to 25 hours per week, and that doesn't affect my eligibility in the plan, so I can still participate in the plan, the group plan. But the problem is, since my hours dropped from 40 hours to 25 hours, now I'm really going to have a hard time paying for my premiums. In that case, I might be able to go to the marketplace and get cheaper coverage, or perhaps get a subsidy because my hours drop below 30 hours. In that case, that is also a qualifying event as well. So that was a newly added 125 qualifying event. In terms of ProBenefits plans, ProBenefits clients do not need an update to the SPD. Our clients' documents currently allow all qualifying events permitted by the IRS, including subsequently approved IRS qualifying events. So these new qualifying events are basically already included in the SPD, and no update is necessary. And in order to allow employees to drop for these qualifying events, employers simply need to notify employees about the permitted changes and allow them to make a change. Jamie, I'll pass it back over to you.
Thanks, Chris. One of the questions that I'm going to go ahead and address, one of the questions that's come into our question box going back to some basics of 125 plans that I mentioned at the beginning of this presentation. 125 plans are the only way for employees to pre-tax health and welfare benefits. So the question came in, what about HRAs, or health reimbursement arrangements? HRAs are covered under a separate section of the tax code, section 105, and HRAs are strictly employer funded. There's no employee funding of HRAs, so that's why HRAs are not included in the 125 plan. 125 plans are truly just for a way for employees to pre-tax contributions. Certainly in an HRA plan, if the employer is providing one to their employees and funding that HRA, certainly those reimbursements to the employee those reimbursements are tax-free. But HRAs do not fall under the 125 plan rules and regulations. So let's talk a little bit about health FSA carryover. Most of you do know that one of the big changes last year that came about regarding Section 125 plans, particularly health FSAs, is that now the government came out with a new rule around Halloween of last year that said employers, you can now allow your employees to carry over up to $500 of unused health FSA amounts at the end of the plan year. So January 1st of 2015, it will be the first renewal for calendar year plans when employers will truly be able to educate their employees about the carryover. Because when the regulations came out last year at Halloween, we were kind of already in the middle of 2014 open enrollment. So this will be the first time that if you've adopted carryover in your plan, you'll be able to truly educate your employees about that. And I think that's really important in terms of the employee education, because this carryover provision, if you as the employer are allowing it, it totally gets rid of the employee's use it or lose it objection to participation. The grace period, we have a optional 75-day grace period as well. That never really got rid of the use it or lose it objection, but carryover does get rid of that, so you get more people jumping into the health FSA. We have discussed this carryover topic at length in previous webinars, including some of the various following issues. If you as an employer are allowing the $500 carryover, the summary plan description should be updated, the needs there. We've also talked about carryover versus the grace period that I just mentioned. What's better, what's worse. In our minds, carryover is much better than the 75-day grace period, and to be quite honest, we do feel like that the grace period will eventually just die a slow death because employers would just go to the carryover option. Carryover and HSA eligibility, what are the implications there? Certainly that if an employee is covered by a health FSA and has money available to them in the health FSA, that prevents them from being able to contribute to an HSA. So those issues, we've talked about that. Carryover and COBRA, how carryover impacts whether an employee needs to be offered COBRA on their health FSA, we've discussed that. So if you want to learn more about those topics, we encourage you to go to our website, find our previous webinars, and you can view those webinars to get more information on those topics. And again, as Chris mentioned, you can always reach out to us as well. And for employers, if you do want to allow carryover, you just need to talk with whoever's administering your health FSA, whoever's administering your 125 plan, and get them to add carryover to their plan and to your plan documents. Another issue that comes up a lot when I'm talking to employers and advisors is the issue of short 125 plan years. So the question is, should I align my 125 plan with or without FSAs with my benefits renewal plan year? So, if I've got an existing 125 plan that's on a calendar year basis and my health insurance renews July 1st, should I align those? And the short answer is yes, you should align those if it's possible. And again, a short plan year on the 125 plan may be required to do this. There are two primary reasons to make that short plan year happen. The first is just overall compliance. When you think about your 125 plan, again, if we go back to the models that I discussed earlier, you've got the basic POP plan, and then you've got an expanded FSA plan that has both pre-tax premiums and FSAs. The pre-tax premium portion of an employer's 125 plan really dictates when open enrollment should occur in the component health and welfare benefits that are being pre-taxed. So let me give you an example. Let's say your 125 plan year is on a calendar year basis, but your medical plan renews 7/1. The medical plan, you're probably doing open enrollment on the medical plan for 7/1 in this example. Well, that open enrollment period could be out of compliance since the 125 plan is on a calendar year basis. And the 125 plan really dictates when open enrollment can occur for the medical plan because it's a pre-tax benefit. We mentioned this earlier when Chris was talking about qualifying events. An employee, when they're pre-taxing benefits, they are locked into their election for the plan year. So if your 125 plan is on a calendar year basis and employees are pre-taxing those medical premiums, but your medical plan is on a 7/1 renewal basis, technically open enrollment should be occurring on a calendar year basis. So from an overall compliance picture, it's just best to align these two benefits. And then from a practicality standpoint, there is no better time if you have a health FSA in your 125 plan, there is no better time to make a new election in your health FSA than when your medical plan renews for the next year because you know what your benefits are going to look like for the next year. So that's a good time to be able to make a new election in the health FSA. So short plan years are certainly a topic that we talk about a lot. Also, another topic that we discuss a decent bit. And I want to go back to the short 125 plan years really quickly. I also mentioned this. If you decide to run a short 125 plan year, you need to make sure that you update your plan, your SPD on your plan. And also make sure that your administrator who's administering your 125 plan, make sure they can accommodate a short plan year. I certainly have seen that some administrators not be able to accommodate a short plan year. That's certainly no problem here at ProBenefits, but I wanted to mention those two things. Again, another issue that we talked some about, HSA contributions. Certainly, as I mentioned in the basics of 125 plans at the beginning of this presentation, health savings account contributions can be made pre-tax through a Section 125 plan. So we get that question a lot, and the answer is, yeah, they can be made pre-tax through a 125 plan, both employee and employer contributions. And honestly, this is the preferred method, since employer contributions outside of a Section 125 plan, so employer contributions into HSAs outside of a Section 125 plan, must comply with very strict comparability rules. So it's best to run HSA contributions through the 125 plan. Employer plus employee contributions cannot exceed the annual limit for HSA contributions for 2015. I think those are for employee-only coverage, $3,350, and family coverage, the family limit, $6,650 into the HSA. That employer plus employee cap is certainly different in HSAs than it is in FSAs. If you have an employer that's contributing to a health FSA, that employer contribution does not count towards the employee maximum. So a little bit of difference there. Again, if you have HSAs and employees are putting money into HSAs and you're taking those out of their paycheck on a pre-tax basis, so it's running through your 125 plan, your 125 document needs to include HSAs as an eligible benefit. So keep that in mind. Your 125 document, your plan doc, should include HSAs as an eligible pre-tax benefit. For employees that are ineligible to participate in the 125 plan, and I have this discussion a lot of times with employers and advisors with 125 plans, depending on how a company is taxed, there are certain employees, owners, et cetera, key employees that may be ineligible to participate in the 125 plan. They might not be able to pre-tax anything. The contributions to an HSA can be made on a post-tax basis. Now, certainly the employer and the employee lose out on the FICA savings portion, but the employee can still deduct those contributions when they're filing their individual income taxes at the end of the year. So the employee, even if they have to make post-tax contributions to an HSA, they still get the tax break when they file their taxes at the end of the year, so they save on federal and state, but they don't save on FICA because we can't do it through their paychecks anymore. Also, I'm going to go back to this slide as well. I do want to mention this also. If you are an employer and you're considering adding HSAs, let's say mid-year, in your 125 plan, there are certainly some complications that can arise there, especially if you have health FSAs in place for your employees. So I do want to mention that as well. If you're considering implementing HSAs mid-125 plan year, there can be some substantial compliance issues there. So keep that in mind. Certainly reach out to an administrator or advisor that can help you sort through those issues. We have various resources available to you, there are various resources available to you regarding 125 plans. Certainly rollover, carryover materials, separate summaries for employer and FSA participants. We have some available on our website or upon request. So if you want more information on the carryover provision on health FSAs, certainly reach out to us or go to our website. And I do want to mention our website as well, ProBenefits.com. We've recently just launched a new version of the website. There's some great resources on there, including an Ask the Expert blog. So I want to encourage you to use that. Go to our website, use that as a resource. We think it's a great resource for you, and you'll be able to seek out some answers to burning questions that you have regarding 125 plans or anything that we do here at ProBenefits. Also, as Chris mentioned, IRS Notice 2014-55, that covers the new permitted Section 125 election changes. We do have Section 125 tax savings worksheets available. If you as an employer are wanting to see how much a 125 plan could save you and your employees in terms of taxes, we have those available as well. And then again, use us as a resource at ProBenefits. We are in the business of plan administration and compliance. We do admin for FSA, HRA, HSA, COBRA, premium only, Section 125 plans. We also do Form 5500 preparation for health and welfare benefits for groups that applies to, typically over 100 in various health and welfare benefit plans. We also have available to you through Jason Cogdill, one of our attorneys here, some healthcare reform education advising services for employers and employer advisors, various workshops, training sessions, and employer advising sessions. So if you are interested in that, reach out to us. And then again, as Chris mentioned, reach out to us with any questions that you have, whether it be to Chris from the compliance perspective, or to me, or to Charles Crabb in our office, or to Kim Maliolo, regarding plan setups and questions. We are the benefits consultants here and be more than happy to answer your questions about what we do and how we could help you and your employees. Chris, I'm going to turn it back over to you.
Thanks, Jamie. And I know some of you might need to run off. If you do need to run off, then go ahead. We're going to stick around and answer a few more questions. And of course, as always, I forgot to mention this at the beginning, but everyone will get a copy of the slides and a copy of the recording within the next day or so. So if you need to run off, you'll certainly have the recording emailed to you. So let me just jump into a few of the questions here. The first question is, can an employer include a benefit under the Section 125 plan even if there is no cost to the employee, so that the employer can take advantage of the tax deferral on the cost? And the answer is yes, and we see this a lot with what Jamie was talking about in terms of HSA contributions. Even if the employer is making the full HSA contribution, it can be run through a 125 plan in order to get the tax savings. And it might also come up in a scenario where an employer is paying the full premium, say for long-term or short-term disability or dental or vision plan. And in that case, those benefits can still be run through the 125 plan, even if the employer is paying the full premiums to get the tax savings. Another question is, and this is going back to the FSA Maximum, if the renewal plan starts December 1st, 2014, then can our employees only elect 2,500? And the answer is yes. The 2550 only goes into effect beginning with plans starting 1/1/2015 or after. So that December 1 plan is basically going to have to wait until next December to offer the 2550 max. We have a couple questions, Jamie, about the new qualifying events. Would you be able to scroll back to that slide in the presentation for us? The first question is under option 2, what if they want to drop coverage and not get other coverage? And the answer is that they would not be able to drop. That would not be a qualifying event. One of the conditions for the second qualifying event is if their hours drop below 30, they must enroll in another medical plan, whether that be Marketplace or another employer. They can't not enroll in another plan. So that is one of the conditions in allowing the employee to drop coverage under that second new qualifying event. Another question regarding the new qualifying events, and number 2 specifically, is if the hours of the spouse of the covered employee drops below 30 hours, is this a qualifying event for the employee? And again, the answer is no. In order for it to be a qualifying event for the employee, it must be the employee's hours that drop below 30. And then one final question in terms of the new qualifying events is enrollment in an individual plan a qualifying event? And again, that answer is no as well. So the IRS has solved the election lock problem for individuals that want to go get coverage on the marketplace, on the federal exchanges, but that election lock problem still exists if an individual wants to go get an individual plan. So if they go get coverage in an individual plan, then under the first new qualifying event, that would not count to allow the employee to drop coverage. Jamie, maybe you want to jump in on this question. It asks if we can expand a bit on the term life insurance up to $50K pre-tax.
No problem, Chris. Yes, so if we go back to one of the eligible premiums that can be pre-taxed through a 125 plan, it is group term life on the employee themselves up to $50,000 of coverage. So if an employer is offering the employee the ability to get more than $50,000 of coverage, and they want to allow the employee to pre-tax the premiums on the first $50,000 and then everything else make them pay with after-tax, the employer needs to figure out what part of the premium is applicable to the first $50,000 and what part of the premium is applicable to the amount over $50,000, and then take out those pre-tax, post-tax as it pertains to the premiums. Also, the premiums, just because the premiums on the first $50,000 of coverage can be pre-taxed, that does not mean that the life insurance benefit, if somebody were to pass away, would be taxed. That is still a tax-free benefit. That's one of the benefits of life insurance, is it's a tax-free event for that employee, for the person that receives the employee's death benefit. So just because the premiums can be pre-taxed does not affect the tax savings on the life insurance benefit. Because of this separation of pre-tax versus post-tax on the premiums, most employers I see do exclude group life from their 125 plan, because a lot of employers just don't want to figure up what part of the premium should be pre-tax, what part of the premium should be post-tax. So they just say, you know what, life insurance, it's a small amount anyway for group term life. They just take it out on a post-tax basis. Chris, I saw one of the other questions that came in about the slides. We will email the slides out after we're concluded with this. We'll get these slides out to all attendees in the next few days, so don't worry about that. And we are recording this webinar. We will load this webinar have it available on our website sometime soon as well.
Thanks, Jamie. I think there's just a couple more good questions I want to get to. Obviously, if any of you need to go ahead. One of the questions says, you indicated that HSA contributions should be included in the Section 125 data. How would the employer know what the employee contributes directly to their individual HSA checking accounts? And for employers, one of the good things about HSA accounts is that a lot of the compliance issues and responsibility fall on the employee themselves. So as long as the employer is not knowingly contributing more into the HSA than is allowed per year, then there really isn't an issue. It's really up to the employee to be monitoring their HSA account and making sure that any amount contributed into the HSA does not exceed the annual limit. So that's one good thing about HSAs for employers, is that not all of, but a lot of the compliance responsibility falls on the employee. Another question says, we have variable hour employees. Once it is determined they are full-time and then participate in our insurance, we have been told they have to remain on our policy for 1 year. Even if their hours drop, they can't come off our policy. But with this new change, it sounds like they can come off. I need to make clear that those qualifying events that I listed are the allowable IRS qualifying events as they pertain to the Section 125 plan, and whether under the Section 125 plan an employee is allowed to drop coverage without violating the irrevocability rule. However, carriers may have different rules in terms of when you can add or drop, and they're not necessarily bound by the 125 rules. So even though you might be able to drop coverage in terms of the 125 plan, and the IRS would allow the drop, you should also practically check with the carrier to make sure that they would allow a drop in that circumstance as well. I find it somewhat hard to believe that they would sort of restrict those qualifying events, restrict them and only offer less qualifying events than the IRS permits, but I would check with the carrier just to make sure. Practically speaking, they may be doing that in some cases. And then I guess that was piggybacking off the last question. Do we need to have the employee provide documentation that they have enrolled in another medical plan? Generally for a qualifying event, for the new qualifying event in enrolling in marketplace coverage, or if the hours drop and they enroll in another plan, you can normally rely on the certification of the employee. So no real documentation is necessary. The only time I would really ask for documentation is if you have some reason to believe that they haven't enrolled in other coverage. But without that, then you can really rely on the certification of the employee.
Chris, I'm going to jump back in here on another question that I came across. Can a person put the max into an HSA and also have an FSA and contribute the max to an FSA as well? We have talked about HSAs, health savings accounts, in a previous webinar. So I encourage you to go to our website and view those previous webinars. But keep in mind that in order for an employee to be eligible for HSAs, they have to have a very specific type of health plan, a health plan that has no copays, and everything applies to deductible up to a certain deductible amount. And also that employee cannot have any other disqualifying coverage. Well, a full-blown health FSA is disqualifying coverage to be able to contribute to an HSA, because the health FSA is seen as first dollar coverage. So a person cannot be putting money into an HSA and also have a full-blown health FSA. Those two do not coexist well together. Now, if an employer allows an employee to have what's known as a limited dental vision FSA, then yes, the employee could put the max, if they have a qualifying health plan, they could put the max into their HSA and then also put the max in the limited dental vision FSA. But again, keep in mind, in general terms, HSAs and FSAs, or HSAs and HRAs, they generally don't play well together. HSAs are kind of their standalone benefit, whereas FSAs and HRAs potentially can play very well together. But keep that in mind.
Okay, I think we have time for one more question, and then we're going to jump off. With the new 125 qualifying life events, does that only apply to medical coverage or other pre-tax benefits as well? It only applies to medical coverage. One of the additional rules in terms of qualifying life events is that in order to make a change, that change needs to be consistent with the qualifying life event that's happening. So in this case, if you're getting coverage on the marketplace, you would be gaining medical coverage. So a change consistent with gaining medical coverage is dropping medical coverage. So the new qualifying life events only apply to medical coverage. Jamie, I think we're going to wrap it up there. If there are one or two questions left, we will certainly respond by email afterwards. But again, thanks to everyone for joining us, and we will see you again next month.